will be a problem we shall use a formula of FILAC, F-I-L-A-C, facts, issues, law applicable, analysis, and your conclusion. Said in law, all answers are correct, but your argument. All right, students, can you hear me now?
Yes, sir, we can hear you.
Yes, I do.
Okay, let us begin. Today we are dealing with law of contract. So whoever has a phone has the right to download what we call Contracts Act of 2010. That could be the principal law that shall be guiding us. So I was still clarifying on how we shall answer. We said that all questions which are in a problem format. It is a story which is a narrated that is expecting you to raise the legal issues and address them accordingly. Of course, raising it and defending, you shall have to use authorities, among which the authorities to use are the cases or case laws and statutes. The way I've just indicated that whoever has a phone can download the Contracts Act. An act is a statute. A statute is an act of parliament, can come as an objective. But then, besides every topic, almost has a statute that we shall use. If we are dealing with company law, we shall not use Contracts Act, but we shall use Companies Act of 2012. If we are dealing with employment law, we can't use Companies Act, but rather Employment Act of 2006. If we are dealing with banking and negotiable instruments, there are various statutes that we shall be employing or we shall use, which among others include the Bank of Uganda Act, the Financial Institutions Act, among others. So every topic will guide us on which act we shall use. Nevertheless, it is not a crime once you don't appreciate the section. That okay? Because we are going to define, for instance, today, as we are going to deal with contracts, a law of contracts, our definition is under section 10 of that act. So it is not a crime if you don't know the proper section, but then you at least need to be knowing the principle within that section. That okay, members? Then, if you can't still recall the principle, or if you don't still recall the section, you're expected to be knowing the supporting case. In law, our evidence mostly is obtained through case laws. So any that can be convenient with you, the more that you shall use. But nevertheless, this is the paper that you can answer within 2 answer sheets. Just the first page, the behind page, and you complete the entire exam. Don't need to write excess. Your argumentative perspective can give you marks. How are they recording marks? Brief facts are 45 marks. The issues you raise are also 5 marks. So you already have 10 before you deal with the number. Then whatever you're going to add on those issues, each will be accorded as other marks. Then your conclusion matters, tell us the position you have taken. I said in law, you can add to the extent that you indicate that indeed what they were requesting for is in a negative format. If they say whether there was a valid contract, and for your analysis, you see that all the crucial elements that exist in a contract don't exist in the facts given, then with no doubt, you can indicate that there existed no contract, and you're okay. So it is not about supporting the question, but your analysis. You can either support it or go in a negative form of it. No, the online students must be off because of the power issue. So, but briefly, without wasting time, I may begin with you who are physically here, but then I will need to pick because you need equal services. So it's better let us be appreciating, or as I earlier promised, I may bring a question and we check out. See? Because these recordings are crucial, whether online or physical, they need them, entire syllabus or entire topics that we discuss. So being a power issue, the physical students may also have a benefit. We can be sharing knowledge on other aspects. Let me check out here some of the objectives. So that this can compose of what we studied last time. Okay, for instance, for those who were present when we were dealing with the fundamental principles of law, as objective number 1, this was also a previous paper, not of recent, I think a year ago or two. It had the following objectives. And which of the following branches of law governs the relationship between individuals and states? Which of the following branches of law governs the relationship between individuals and states? A, private law. B, public law. C, criminal law. And D, civil law. Which one governs the relationship between individuals and states? Yes, for those who were present under classifications last time, the answer must be there. It is a branch of law that governs individuals. The relationship between individuals and states. Is it a public law? Is it a private law? Is it criminal law or civil law? I hear civil law. Is it the anonymous answer? What's the different one? Yes? Private. Public. So I hear two answers. Which is the most correct? The branch of law that governs the relationship between individuals and state. Criminal or public? Check in your classifications and you read. Check in your classifications and one should read for us the two where they are differentiated. Because there's a difference between civil law and criminal law. Then we have private law and public. So I want those two definitions that's entirely based on public law and also criminal law. Who has the one of criminal law first? Yes? Yes, under your notes. That's why we'll empower you to go and get the hard copy, the books. You can read for us. Yes? Good. Then go to public law. That governs, yes? Okay. So what is the difference between a citizen and an individual? Simple logic. The answer was very clear. It was which one? Criminal or public? That was a public law. And it was the first number that exam. Let me check another one, which is basically concerning with the rules governing.
Tekuli sih ada. Ada mana nggak suka tekuli?
Mr. Julius, can you please mute your mic? Okay. Still a power issue? Yes? Okay, online students, can you hear me still? Yes or no?
Yes, we can get you.
Okay, I'll be sorry with projection, but then if you can hear me, then strictly let me pass it to the topic of the day so that we can expand. More questions are here, I'm going to share them, and then can help to get more answering and techniques. Basically, today we are dealing with a lot of thoughts, and without wasting time, the definition of what I mean, today we are dealing with law contracts. So the definition of a contract is in your Contracts Act of 2010, basically under section 10. Any with an act or with a book. Whoever has an act can take for us section 10. Whoever can Google it, still, same section will be present. Nevertheless, a contract itself, most of you have made contracts. If we are going to buy an item, it is a contract. Signing in terms of purchasing land is a contract. At your workplace, whenever you're given rules and regulations, and also signing a document in case that you're an employee, you're still signing a contract. Only that now it is named employment contract. So we shall see the various types of contracts and also the nature. But then basically, a contract is that legal binding agreement, a legal binding agreement made between contracting parties. Can you make a contract alone? So we are going to see some of the elements that indeed in a contract cannot be made by one person. So there must be parties. Then beside, there must be a law recognizing for the same. So it is a contract which is binding or an agreement binding between the contracting parties and the performance of which the law recognizes the duty of the parties and where non-performance of the law gives a remedy. In other words, it is that agreement that the two parties make, and there must be an element that is enforced. Can you contract to kill a person, and in case the other person fails to kill, let's say, live example in Bujingo's case, you employ somebody to go and shoot, then the person fails to die, and your essence was to kill. You said, I will give you 1 billion if a person dies, then the other person doesn't die. Can you still pay? Besides, can this person also who was supposed to kill and then the fellow never died, can he sue you? Isn't it a contract? It's what? So the answer, the lady has it, that it is a contract but illegal. In other words, it is not enforced. Because contracting, we are going to see that you cannot contract against the public policy. So In a simple and precise definition of what amounts to a contract, we shall define it to mean an agreement with free consent. Can you enter into a contract when you're forced? That being, I demand you 1 million, please sign that you have sold this land to me. You sign. Can that be recognized as a contract? So we are going to see that the first issue or element is that you must enter a contract with a free consent when you're willing. So it is an agreement with free consent of parties who have capacity to contract for a lawful consideration and with the intention to make it legally bound. Those are the only elements I want you to appreciate in a definition. A contract is an agreement. That is the first element that you need to put in your mind. Contract is an agreement with free consent. In other words, you're not forced, you're willing. Then the free consent of parties. That means that you cannot contract when you are alone. Must be more than one. Then with capacity, we are going to see who has capacity. Can a 10-year child contract? Yes or no? It's serious. Haven't you been sending your children to buy some items when they are below 18 years? Depends on the value. How? What if he passed with the D1 in mathematics and he knows how to calculate? That with the 10,000, if he goes to buy a set, which is of 5K, and bring a balance of 5K. And he contract. So you mean minors don't contract? So we are going to see under what instances that capacity may undergo. Can the drunkard contract? Yes or no? Does he have capacity contract? So then we are going to see that with the law, drunkards also are given a chance to contract. Then, even if he has bought 2 beers and is still ordering for the 3rd one, then that's a contract. So why are you saying that the drunkard cannot contract? They also enter contracts, but we're going to see conditions under which can permit them contract. Then, after the capacity of those parties, the capacity to contract, that contract must have a lawful consideration. What amounts to lawful and what amounts to consideration? Consideration is that exchange, and mostly it is in monetary value. So even if it is a dollar, even if it is a Ugandan shilling or any other item, can amount to consideration. What if we make a contract, or we agree, we make an agreement that in a levy or in a view of giving you my suit, I just need a phone. That's a contract. What is the consideration there? Yes? So we are going to see whether it can amount to a contract. But then another person can say it is a barter trade, exchange for goods of with goods. Barter trade a contract? All those answers shall be indicated within the perimeters of what amounts to a contract. So, is a fellow which is making noise which is not allowed. Mr. Julius, please. Having issues. Okay. Nevertheless, So that is basically the definition of what amounts to a contract. That is an agreement made with a free consent of parties who have capacity contract for a lawful consideration and with the intention of making it legally. I'm clear with one of those terms. Because all the elements are within that definition. The first element should be an agreement, followed by consent, free consent of parties. So there must be a free consent. Then there must be parties. Is also an element in a contract. Besides capacity, then lawful consideration, and the intention of making it legally bound. So, leaving that aside, that within the definition we shall obstruct our elements. But then, before we go for the elements in a contract, let us first appreciate the forms of contract. How can you contract? There are only 4 ways under which a person can contract. That's been coming as a question under section B, basically number 5. So, various forms of a contract. A contract can be entered into in writing. So, the first form of a contract are written contracts. Written contracts are those contracts which are induced in writing. Can you purchase land without forming an agreement or in writing? You have those who sell land verbally. Just agree. But then I had one getting that he inherited. Should we consider it to be a contract? My father gave me a chunk of land, 20 hectares. So the person who I have a contract. I'm the owner of that land. Anyway, basically, one of the forms of a contract is that the contract must be in writing. And with the law, it is very clear. Any agreement that you enter into while contracting that exceeds 50 currency points must be in writing. That A bought his car worthy, agreed with B, sell him a car of 20 millions. However, A never paid full amount since they never signed anyway. But B is also not willing to deliver the car. The wife of A is demanding harshly and is emphasizing that if not B, is going to sue B. Advise the party. Vehicle is worth 50 million. But then the contract was made verbally. Can the wife enforce that kind of a contract? The answer is under written contracts. Basically, that a contract whose subject matter exceeds 500 Ugandan shillings, 500,000 Ugandan shillings, it must be, it is a must, mandatory, must be in writing. So it comes as a problem question, indicating that this person was purchasing any item which was beyond 500,000 Ugandan shillings, which is equivalent to 20 currency points. It must be in writing. Are we clear on that element? For clarity of currency points, it is under your part X or part 10 of your Contract Act. It is the last element in the Contract Act. They indicated that a currency point is 20,000 shillings. One currency point is 20,000. So if they say that any currency point that exceeds 50 or 20, you calculate. It's a matter of multiplying. No. how much. So basically, the first form of a contract is that contract must be in writing, or you can express the contract in writing. That's the first format. Followed by that, there are also a second one known as an oral contract. That essence of going to the shop and you just buy, go home. That is the total contract that you have made, but orally or verbally made. So what amounts to oral contracts? Those are the contracts which are not used into writing. So it is the opposite of the first one. You have a question? Yes. Which is reduced, which is not reduced. It must have been classified as induced into. Induced. Now changing into. So written contracts are those which must be in writing. Then the oral ones, which don't need to be in writing. In other words, any contract that you can make that is below 50,000 Ghanaian shillings, then it is worth not to make it into writing. That okay, members? Yes or no? So if you're purchasing a bicycle at just 30,000 or 300 or 400 or even 490, you can still leave it open without inducing it into writing. And can be recognized as a contract, which is verbally made, or oral contract. Then the third form of a contract are contracts which are implied contracts. Your notes, they are very clear that implied contracts are those contracts which are by conduct of parties without necessarily being in writing or oral form. They also fall under the general category of simple contracts, and as such, must be supported by consideration. For instance, a passenger and a bus owner. Implied contracts. Let me give a simple classification of what amounts to implied. If A has a vehicle and he takes it to a washing bay daily, he pays 10K daily. But on the 10th day, he fails to pay, but promises that I will bring the amount. On the 11th day, he brings 15 instead of 10 of each and every day. That means he has failed to deliver another 5K. The 13th day also fails to pay. After a consecutive week without paying, he brings 100K at once. What does it mean? That is missing in terms of daily payment. But then those who are persistent, in terms they only watch every day whether he pays or not. If this person brings it for entire month without paying, can the washing bay personnel sue that very person, the owner of the vehicle? Yes or no? He has been paying. Later he paid in full, pays, comes back, pays. Then now he has lasted the entire month without paying. And he's telling them that we don't have any formal signing where I've been paying you. Can you sue that person? Yes or no? And if yes, please confirm with your supporting argument. I said yes. We are on implied terms. That is, we have first appreciated that we have two forms of the contract. One being written, another being oral, which doesn't need to be in writing, Then the third one is implied. Implied contracts. At times we call it implied by the parties. In other words, how parties have been behaving. If I pay you today, the next day I don't pay you, then another day still, I don't pay you, then I bring all some amount at once, I still spend a week without paying. There is an existing contract. So we shall see if you have been appearing. And if yes, then how have you been paying? Once we appreciate that you have been appearing and paying, then we can still demand the entire price. Maybe for that fact, at times you may find that this person was paying 10K, another day 5K, 2K, then 5K, 10K, without a consistent price. Still, we can evaluate that roughly. If your paying schedule was in this format, then you at least ought to have paid this amount. That is what we mean by implied, how parties have been behaving towards a particular contract. Are we okay, members, with the implied contract? It deals with the character and behaviors of the parties and is recognized. That means whether the person has been issuing you with receipts or not, but your character towards him in terms of payment and getting the services or the goods can still evaluate to amount to a contract. And then there, we shall only confirm that it's an implied contract. Some of you have that tendency. Go to the hotel, you eat, then you indicate that you will pay after the month. As the month ends, you pay. Then you make it in consistency. That now let me go and spend another month and I don't pay, and I just quit. So that is an implied contract. There is an existing contract. The person can sue you and succeed against you. Same applies to those who stay in rooms, the rental. You pay for this month, the next month, then you want to quit without payments. That person can sue you. Whether he has been issuing you with receipts or not, you have an implied contract. Are we okay, members? And the last form of the contract is partly oral and partly writing. In other words, this one carries two forms. Person, there we have an explanation that under partly oral and partly written contracts, there are contracts requiring written evidence, such as requirement is not for a special written form of a contract, but there is a note of memorandum in writing signed by the parties or person lawfully authorized by a party. So we have such kind of contract that you can make and sign. Then the next time, don't sign. Then at a later moment, one person is states that I paid you. Mostly with these mortgage issues. When the person has advanced the loan to you, you have acknowledged it. Next day, as he's demanding, you find him in a chat, gives you 1 million, just pocket it. You leave. So if there is evidence, any element that in case that this person pays you and you issue receipt, at times you don't issue receipts. Once you accept that indeed I had issued him a receipt at first, but the other time I never issued him a receipt. And now it's containing that even the third time he paid you money, which you're now denying, that contract shall be referred to as an implied, a contract which is partially or partly oral and partly written. Any question in terms of the 4 forms of a contract? Me appreciating that we have written contracts, oral contracts, implied contracts, so implied by the parties, and lastly, partly oral and partly written. Those are the only 4 forms of a contract which can be recognized. So if a problem question comes with any of those elements, getting that A and B reached an agreement and this person paid this, then he paid this amount on demand, indicated that nobody saw him, but this person had paid. So you can indicate that still a contract can be made partly oral and partly written, and you support that there was a valid contract. So a contract doesn't necessarily mean be the one which is in writing. Neither would it be only an oral contract. Unless if there is a question in terms of the forms, the four forms of making a contract, or forms of a contract. If not, then we go to the various elements. Having known that we can make all those contracts, whether written or oral or implied, or partially written and oral, let us see the various elements of a contract. I've just given you a formula that within the elements, they are all obtained through the definition, which is under section 10, subsection 1 of the Contracts Act of 2010. Pardon? Yeah, but I doubt whether there's power. It was then I should be protected. And one could help me and call another person so that we can protect. I need to assist me and call one of the So basically, those are the forms. But then with the elements, you must appreciate them through the definition. Don't have any other element which is beside the definition on implied. How parties behave towards that contract or towards doing an item. If I've been paying, let's have come to purchase the phone, and you indicate that the phone is 1 million. Then I start depositing. The best example could be the one of washing bay. You have your vehicle, you take it each and every day for washing. The first day you pay them 10K, second day you give them 5K. The third day you don't pay them. Another day you come with 20K. In other words, you don't have a consistent price that you're giving. But then after a week, you're taking it, they are washing, but you're not giving them a consideration. You're not paying them anymore. If this person demands, do you indicate that you don't have, it doesn't have a valid contract with you? Yes, if it's now demanding, it's like, for the last 5 days, you haven't paid anything. Can you pay it? Can you deny that there's no contract? So that is what we mean by implied. How parties have been behaving towards that character. Okay, any other question? Pardon? Hoping are not visible. Oh, only the sides. Like that. Okay. So that's fine, that's fine. So having appreciated the 4 forms of a contract, allow me to also appreciate or give you the various elements of a contract. I've said elements can be driven from section 10, subsection 1, the Contracts Act 2010, and it is the definition of what amounts to a contract. We said, what is the first element in a contract? I mean, what is the definition? A contract is, so the first element in a contract is an agreement. There must be an agreement. What does it mean? That since nobody can agree with himself, there must be at least 2 parties to an agreement. One of them willing to make an offer, and another one willing, and another will indicate acceptance. When offer and acceptance correspond, each to every respect, it is an agreement. So there must be that element of 2 parties one willing to offer something, to give out something, and another person willing to take it over. That's why we are going to see another definition arising from what an offer and an invitation to treat. Are going to be somehow look to be familiar, but then they are totally different. So in this regard, you have something you're giving out. There's also something the other person is supposed to, another person is willing to accept, then give their consideration. So an agreement always goes with the parties, where one is offering something and another one, in case that he has appreciated, he has accepted to take that offer. The second element in a contract is that the parties must intend their agreement to result into a legal relation. That's why I gave you an example of Jingo's scenario. If you're hired to kill and a person has hired you, gives you part payment, pays you halfway, you finish your mission of killing, and you're now demanding for the balance. And this very person fails to clear you the balance. Can you sue that person? Yes, no. Yes, how? Yes, there's an agreement. Yes, they accepted to take over that offer. No, even if he did it, but then it's money, or even if he paid. Is killing allowed in Uganda? No. What if I give you 10 million to go and get timber in Mavila Forest? Is it my forest? So even if you cultivate all the trees, can it still consider to be a contract? So there must be an intention, an element of legal relations. In other words, once the person fails to meet his obligations, you have the right to sue him. But then you cannot sue under the contracts which are not allowed. That's why we shall still at the end of towards the end, we shall see what amounts to a valid contract. Of course, the valid contract is that contract which has all the elements existing. Then we are going to see contracts which are void, V-O-I-D, a contract which cannot be enforced. For example, contracts against public policy, contracts which have restrictions in accordance with the law and the rest. Then we are going to see what also another element of voidable contracts that has all the valid elements, but a party has failed to meet the condition in a contract. So, but besides, let us first appreciate that all the parties must intend that their agreement they have made must have a result of making it a legal relation. In other words, once you fail to do what you're supposed to do, the other party has a chance to sue you. That's what it means. That this is where the parties must intend that if one party or one of them fails to fulfill the promise or undertake to the by the agreement, he shall be answerable the courts of law. So that's the second element. The third is about consideration. That there must be a valid consideration, or there must be consideration for a contract to exist. And I've said that consideration, mostly in contracts, we are dealing with monetary value, no matter which currency, but if it is a monetary value. That's why I was giving an example that if we exchange a suit and a phone, does it still amount to a contract? Yes or no? We are exchanging only. Is there a consideration? So we are going to see, but then every contract must have consideration. As one is willing to offer something, upon the other person accepting is also giving you a return, which is known as the consideration. And besides, we are going to see the rules governing the consideration. I think it must be in this speaking where they asked for the rules governing. Is it acceptance, consideration, or offer? Any of the three. There's a number which came. I think I'm going to trace it, I have it with me, then we see. But then you must appreciate, because if they said about offer, this time it can be consideration. So that is the interchange or the changing they normally make. Then number 4, that the parties among the elements, beside consideration, beside the intentions of the parties, and also beside an agreement, we have capacity. There must be, or the parties must have the capacity to contract. And the last element of it is that the reality of the contract. Reality is that outward, what comes after. Is it going to be a valid contract? Is it going to be voidable? Is it going to be valid, enforceable? So what comes once you make a contract? It's the reality, or the consequences that come after are also one of the elements of the contract. So within that, we can expand them. Each element can give its expansion. For instance, on the element number 2 of the intention of creating a legal relation, that once you make a contract, you want to make it to be enforced. We have what we know that the intention of create a relation is an element which is necessary in the formation of the contract. Therefore, the parties must have or must have the intention in their contract, what they intend to. You don't give a phone in a way or in a way that you want to rob the person at night and take it back. If then that is your intention, the contract you have made is still void. That okay, members? Yes, your intention matters. It's like recently the stag of Manchester United, for those who support sports. It was on a pitch, they were selling it. And there were 2 or 3 members who were willing to buy. They showed their intentions. So they made their bid also of buying. However, the club also insists that we don't sell it wholesomely. We are only selling in shares. So they are now bringing another intention. But then in a contract, you must make the intention clear. Your intentions can be made express if it is express or meaning writing, or they can be implied. And therefore, among the relationship or the intention of creating a contract, we have whereby we can see the domestic agreements. Some of you merely make statements and you think you have made a contract, an agreement. Tell your wife, I'm very happy for today's supper. I'm going to give you a phone. Is that a contract? Is it orally made? Is it a contract? Being satisfied for supper, you're just offering to give a phone. And the question is that a valid contract? Why? There is no legal intention. Now, whether you give a phone or not, the other person has nowhere to sue you. Is it all? Is there a consideration? Yes, please. Whether oral or not, all contracts must possess the elements. That's the first issue to note. So if there is a lacking element, then that cannot constitute a contract. So I've made a clear statement example that A takes up and is fully satisfied. He promises B the phone. Is it a contract? Why no? Yes, please. Yes, madam. is out of the social relationship. The answer should already be within these elements. You first need to know that, okay, capacity. Was the man capable of making, under capacity? Is he 18 and above? Was he mentally okay? And all other factors that deal with capacity. Secondly, consideration, as is promising a phone. What is the best thing on that you're going to accept and also give? So consideration, is there consideration? Then intentions. Is there an intention that once he fails to fulfill what he has promised, can you sue him? So once you find any lacking element in a contract, then that contract cannot be enforced. So mere one, yes, please. No, can't be only cash. Anything which is capable of, for instance, a bill of exchange. Is it cash? Anything that can be monetized. Anything that can be recognized in terms of an exchange in a currency. Or any form of negotiation which is allowed in terms of the institutions under Bank of England. It could be a check. If I promise and I sign a check, you think that is there's no consideration? Yet I'm giving you a check. It is. So it doesn't necessarily mean stealing. But any form of negotiation, if you have appreciated, for those who are working in a bank, they know the negotiable instrument. So anything which is negotiable in terms of the proximity of banking can be considered to be rightful consideration. Here's some funny noise. And the person making a funny noise is called B. So please, B, can you mute? Okay, thanks. So, yes, please. Any person who can respond back? And if not, first and foremost, contract must be specific. We don't have an uncertainty or something which is which doesn't have a limit. In a contract, there is certainty. So if you bring an element that once I succeed, if you want it to succeed, certainty matters. When are you giving that what you have promised? For instance, if I say that I'm going to issue 1 billion if the war between Ukraine and Russia ends, is that contract enforceable? When is it ending? That should be the matter. So if you tell me that in my one I succeed, when are you succeed? But if you want contract for 20 times, should I wait for those 20 times? So contracts have a particular type. That's why we are going to see that among the elements that can discharge a contract, we are going to see time elapsed, death of the parties. We're going to see elements dealing with agreement, what we have agreed and other aspects. But good enough, we're going to expand it. So I'm going to answer still under the constellation once we reach on each element. That's why we are beginning with the intention. So we're going to see constellation, capacity, each element, we expand on it. Any other? So we were still dealing with the intentions. Which create the legal relations. We have examples of the domestic agreement, just like the one I'd given you for food. One after appreciating supper, making his own premises. But yet those premises cannot be fulfilled. There's the famous case of Balfour versus Balfour. And the clear element is that a husband who was a civil servant in Sierra Leone came to England with his wife. When his leave was nearing its end and he had to return to Sierra Leone, he promised his wife, who, on the doctor's advice, had to return in England, a household allowance of 30 pounds a month until she joined him in Sierra Leone. So this man made a promise. As I'm leaving, I'm going to be sending you 30 million pounds per month until you join me. Hasn't he made an offer? Yes? Okay. So later, the parties separated and the wife sued for that allowance. He wanted his 30 pounds. Since he had not joined him, Sierra Leone again. Would this person succeed? What did court do among the element of held? Court held that domestic agreements such as this were outside the realm of the contract together. Was there consideration? So could it be enforced? I was thinking how these elements come in. And within still, among the elements, it never suits all the elements. Even if there's one element missing, it can affect the entire contract. That okay, members? Let us first appreciate that if there are 5 elements, and we have said all elements are within the definition of what amounts the contract. That's section 10. So if any element misses, unless if that element has exceptions, because we are going to see that capacity, and we shall appreciate that even a person below 18 years can contract. But then we are saying that within the definition, the person who is supposed to contract or to make a contract is the one who has capacity. So we're going to see, as a general rule, for you to enter a contract, you must have capacity. Exceptions, even a drunkard can contract. Even a person who is insane, a lunatic, person who is always at the wrong side. The Lord suffering from almost being a mad person can also contract. Haven't you seen them buying cigarettes? They have capacity. But then we are going to see at what level can we amount that capacity. Okay, so with Balfour versus Balfour, yes, please. Yes. Consideration. What are they considered? That's why even we haven't reached the element of consideration, and you're still having that. Okay, what were the elements which were missing? Okay. Okay. Relations. So there that element of intending it, that once you fail, this is the condition. Once I fail, you must do this. Okay. For the better explanation, if compare this case, Balfour versus Balfour, and the last case there, the one of merit versus merit. Let us read and appreciate the facts concurrently. That okay? Yes, we are considering now this case of merit versus merit. A husband had formed an attachment to another woman, and the spouses intended to separate. They negotiated in a husband's car about some arrangements for the future. Before the wife left the car, she insisted that the husband give her a written statement according to which consideration of her paying the mortgage on the family home, in brackets, which was in the name of the husband. You know mortgage? Some are saying yes, others no. He would transfer that house. In other words, the person wanted the loan. No, the husband had acquired the loan, and what he made as a stake, which we refer to as the mortgage, was the title. That okay? He had staked the land title. So as they were going to separate, this lady, they agreed, they made an agreement, the way we have seen Balfour, just make an agreement. But as a way of indicating that once we separate, how are we dealing with the land title in the bank? There's no option other than we all paying to acquire it. But then they are separated. So this wife went ahead to indicate that even after, as we are separating, allow me to continue making payments since we had acquired the loan together, however much the title was in your name. Let me make all the due payments, acquire the land title back, which is in your name. But then I transfer it to my name because I've cleared. So is there an element of making it legally bound? Once this person completes the payment, can you fail him to acquire the title? Or if he has acquired it, can you fail to make a transfer or sign on transfer forms? So are we seeing how now the element of now ensuring emphasizing the legal bounds in this case? So that's how it ended that he would transfer that house into her sole ownership. The wife paid the mortgage and asked for the transfer of the house. What held that in the rule in Balfour versus Balfour did not apply in this case. The parties reached an agreement when they lived in amity, but in the Pleasance case, they negotiated at arm's length as they had decided to separate, and reasonable person would regard their agreement as intending to be binding in the law. The wife was entitled to a house. At least there is an intention. You're indicating that, okay, however much we have this one in common, if I go ahead and add this element, I can have a basis of suing you. So the question could be was paying in the bank. And even they reached an extent of signing an agreement in the car. So some of the mere statements may not amount to contract, but you must fulfill all the elements. We have also what we call commercial agreements, beside the domestic ones, the one and the husband and the wife. And then we have the commercial ones with the business. So in commercial agreements, the parties will normally change their legal relationship, that is to say, to break them into an agreement, and they shall have the right to succeed in legal proceedings and enforce them. So we have commercial agreements that people normally make in the course of business. You sign just your contracts, your agreements, and now you can enforce them as a part of the contract. Like when you're going to go buy, let's say, TV set, you give them part payments, and you're signing agreements. If this person later fails to oblige, you can sue him based on the evidence of this case. If there is a show, a cinema show, all these kind of promotions that MTN or these other companies make, that whoever, let's say Coca-Cola, had once Chamuka promotion, did you hear of it? that whoever takes order and finds a lead containing a label of a vehicle, he has won a vehicle. Such kind of promotion. Those are commercial agreements. If a person drinks, indeed gets his lead, and you have even prescribed the stages under which you can obtain that item, then once you fail to give, he can sue you. We are going to see the famous case of Karel versus Catholic Smoke Bar Company in terms of commercial, where it will come in terms of the offer, what amounts to an offer and what amounts to an invitation strict. But then know that where there is a stake, for instance, insurance could be the best example. They enter into a company enters into an insurance have an insurance policy with a person. Then they stake some amount in those insurance companies or the bank.
Philo.
Then if you have anything having affected which is within the insurance policy, you can enforce it. That can be a valid contract, isn't it? Yes, for those who have dealt with insurance. So those are some of the commercial agreements.
Nyenda kuzikwasa kale bakabinjire nkabeka.
The Munyankole fellow who is trying to disorganize us, please. Mr. B, can you kindly mute and attend if you're attending? So formation of a contract based on the agreement, let us see each. For instance, an offer, what amounts to an offer? An offer must be distinguished from an invitation to treat. Therefore, an invitation to treat makes an offer. And an invitation to make an offer is not an offer which is capable of being turned to a contract by acceptance. Advertisement is normally only intended to be an invitation to treat or to negotiate. Some of you have often gone to supermarkets, find goods displayed, even with a price tag. Then you just pick. Yet the price tag was indicated in Christmas era. We are in January. Pick an apple. As you go to the counter, the cashier says it's not 1K, but it's now 2K. And you want to box the cashier because the price is on the price, you know, the one which is on the display. Is that an offer? Or we need first appreciate what is an offer and what is an invitation to treat. Why are they inviting you? So let us see. For example, a shopkeeper who displays goods in his window for a ticket, with a ticket on them stating a price, does not make an offer, but merely invites the public to come and make an offer to buy those goods. Therefore, if a customer enters the shop, tenders the price and demands for the article, the shopkeeper is bound to sell it to them. The demand of the customer is the offer which the shopkeeper is free to accept or reject as he raises. So with offers, it is totally different from an invitation to treat. Once you give a price and this person accepts, he has taken over the offer. We are going to see the rules governing offers. But besides, there is this famous case that I need you to first appreciate. Having seen that a mere display of goods is not an offer, but inviting you to come and appreciate. But how you appreciate is when you give the price which the person has stated, which could be even different from what is on the display. If you say that, no, this item is a 2K, and you still accept to pay, then you have taken over that offer. If you can't take an offer, leave it. there is another person who can afford that offer. So we are going to see that even you can make an offer to the entire public. Doesn't necessarily mean that an offer is to an individual. In a pharmaceutical society versus Boots Cash Chemical, goods were sold in Boots in B's shop. That is Boots Cash Chemistry, under the self-service system. Customers selected their purchases from the shelves of which the goods were displayed, put them into the wire basket supplied to B. Supplied by B, and they took them to the cash desk. When they were paid, the price, court held that the contract was made when the customer put the goods into the basket. But when the cashier accepted the offer to buy and receive the price. So this contract, however much is the contract? But now we are only depreciating what amounts to an offer and what amounts to an invitation to trade. So when they picked all those items, took them to the cashier, that was still, this person immediately paying, invited them. It was an invitation treat. Picking them, going to the receptionist or the cashier, it was under invitation treat. They are still taking what they have invited them for. But a mere cashier accepting the price, even if you had indicated that no, each commodity we double it. Then he's like, oh, but it's okay. I know you. Let me accept that amount. If they come and demand for the balance, who is now liable? Is it now this poor purchase or the cashier? So once you accept the offer that this person has given, then now you have taken totally, it has changed from invitation trade to an offer. Let us see a clear example, maybe on what could still amount to an offer. First of all, to know is that an offer may be express or implied. And therefore, a person who makes an offer is known as an offerer. These things come in objectives. A made an offer. Therefore, a person who makes an offer is, then they put offeree, offerer, and other items. They may even put off. And for you, since you wanted a day off, just start off, as if it is an offer. So the person who makes an offer is known as an offerer. The one to whom the offer is made is called an offeree. And now, what item is being displayed is an offer itself. So we have the offer, then the person giving that offer, and now the person accepting the offer. So we have the offerer, offeree, and the offer itself. So examples are that A makes an offer to sell his motorcycle to B at a price of 300 shillings. B promises to pay that 300 shillings for that motorcycle. Is there an offer? Okay. If A, yes, please. A promise and an agreement. First of all, we are going to see what amounts to an agreement. What is an agreement? Yes? Any with an attempt? An understanding between two or more. A mutual understanding. Can 3 people agree? Can't 5 agree? Can't 2? Okay, and now a mutual understanding of the parties is an agreement. Then what is the promise? Yes? and as a promise amount to an agreement? If I promise that whoever scores or whoever becomes, what is the tendency here? Whoever appears to be, they call them what? Prize winners. Whoever scores high is the prize winner. And they offer, it says full bursary for the papers you will do in the next sitting or next level. Is that an offer? Is it a promise? Can the promise be fulfilled or not? So in a promise, you can either fulfill or not. But in an agreement, once you agree, you must fulfill. And that's why we are going to see still what amounts to offers. What amounts to acceptance? What amounts each? That's the definition. So don't worry, we are still going to deal with it. But I'm still illustrating how one can make an offer. And we have said if you promise to sell your motorcycle at 300, then the other person is willing to buy it still at the same price, there's an offer made. And also, where A advertises newspapers offering 5% reward to anybody who returns his translator radio, B brings it to A. Is there an offer? Still yes, because A has promised something, then this person has brought. Okay, then the 3 goes. A bus goes alongside the street. This is an offer on the part of the transport enterprise to carry passengers at the published affairs. The offer is accepted when a person gets into the bus with an intention of becoming a passenger. Are you seeing now the intention of making it legally bound? You come having it in mind that you're going to be a passenger. What if you're just entering to inquire where are they going? Even if you're not going, but you just want to inquire because you want to look for something. Are you still, once you enter, does it amount to an offer? Because you don't want to go, you're not a passenger. What if you're now selling these drugs? You just enter, you're not going anywhere. Are you a passenger still? So intentions also matter in a contract. So whenever there is a modern bus and the customer pays the driver on entrance, it is probably the case that the customer makes an offer when he asks for a ticket for his destination. He has paid. So why can't he request for the ticket? So the driver accepts the offer by issuing a ticket. The driver may even fail or accept your offer. You have often seen it in Christmas period or festival errors. You bring your 50,000 to Mbala, they say no. The amount is at 70. We are not accepting. Can you sue them that you made your offer and they rejected it? You're heading to Ginger, the affairs are 20,000. Yet the normal price is 10. And now you're complaining. I gave him 10, 15, but he rejected. Yet the normal price is 10. And you're also aware that it's a Facebook. So once this person accepts your fee, then he has taken over the offer you have given him. Okay. So that an offer may be made to a definite people. So many people. You can make an offer to the entire public, or some definite class of persons, or to the entire world. An offer to a definite people can be accepted only by that person, or and by none other than that one. Guess the point. Which school gave the offer to Champion Gudo recently when there was a struggle? Some conflicts in terms of the studying issue. Kampala parents, did he take the offer? Was it made to the entire public? Yes? because Felista requested for that offer. Please, once you do a favor and give Champion Budo an offer to study from Kampala parents, I'll be glad as my fellow artist. Kampala parents committee agreed to give an offer particularly to Champion Budo. The man laid down that offer. So that means that an offer can be either based on individual or class of people or entire public. But that offer was basically to a particular person. We get the point? So let us see an example where you can make an offer to the entire public. That one can be only illustrated in that case. The real versus symbolic smoke ball company, 1893 Queen's Bench at page 256. That's why I said that at least if you can cram a name or the party, the real versus symbolic, it is okay. If you can recall one name, which is Kareel, it's still okay. In Kareel's case, then you explain. Please, I don't expect you to go and quote the wrong year. Unless if you know that they say that year, you still remember it very well to quote it. If you can't know where it is illustrated, that's why they put QB, Queen's Bench. We have King's Bench. We have Kampala reports. We have other citations. So if you can't recall, please just put the names of the party. Even if you don't recall, only bring the principle. Know that the offer can be made by the offerer to the offeree. As simple as that. It can be made to the entire public or individual or class of people. As simple as that. Yes, please. Is there a question?
Mugamba mpe akumpereko ku earphone kyona kyalina ba earphone ba headphone oba buli obutono akumpereko.
Okay. So we are indicating how now let us see an illustration whereby an offer can be made to the entire public. In Kareel versus Symbolic Smoke Ball Company. That company was manufacturing drugs known as influenza drugs. That's why they are indicating that Symbolic Smoke Ball Company offered by the way of reward £100 to everybody who contracted with influenza. After using their smoke ball, which was described, the offer stated that it had loaded to £1,000. Once you load £1,000, then you have intention of creating it to be legally bound. So it is a stake that once I fail to give you, once you use my drug and you fail, then I'm paying you how much? This, because I want to contract with the disease having taken the prescribed drug, then it could be refunded with £100. Then, as a way of emphasizing that they meant it to be enforced, they went ahead to load £1,000 in that bank, Alliance Bank. So, what happened to Kareel? Mrs. Kareel used the smoke ball as prescribed, but notwithstanding, he contracted with the same disease of influenza. She claimed for £100. However, court held that the company was bound to pay. Why? The company raised a defense of not paying, indicating that an offer cannot be made to the entire public. But then the judges were very clear that a mere taking this, you intended it to be legally bound. Therefore, this person is entitled to that amount. So you can make an offer to the entire public. That is the simple illustration. Taking is now almost same fact with Meliti case, different from the Barfa case, but almost similar facts. So, for you to know that there is an offer, These are the things you need to put in consideration. One, every offer must be communicated. That okay, members? If I lose a phone and I don't indicate that whoever picks my phone is entitled to 50,000 shillings, then you bring it to me. Can you tell me to give you the reward? Yes or no? I've lost the phone, or you have picked it and brought it to me. And now you're like, please, dangers and disaster. There was no offer, so whether you bring it or not. But if there is an offer, then I communicate. I say that whoever picks my phone is entitled to. That's why we are those announcements. Are not they fake? Yes. That whoever I lost my pass slip, ABCD documents in a bag, so whoever picks it. You apply what we studied last time, interpretation of the interpretations, the legal interpretations, where we said we have the literal rule. If there has a clear, now we are going to see if it is the literal rule. The rules governing interpretations. We studied them last time. And we said there are like 6. We said that literal rule, you give the word ordinary meaning. So if a person says that whoever picks my work is entitled to, what does it mean? So is it a mere fact of appearing and then the man shakes hands and you go? Obviously, no, then we shall now constitute that person, say, what did you intend to mean by appreciating his 2 hands? And once you give us something that is not worth to be appreciated by 2 hands, we can still sue you. We want that ordinary, what did you intend? So interpretation still now goes ahead to use its importance. Okay, but all offers for the offer to be known must be communicated. So all offers must be communicated to the offeree before they are accepted. So it is up to you to say that no, this man said that whoever picks this phone is entitled to 50,000 shillings. But for my thing, 50,000 is not worth it for me. You just leave. So whoever wants this offer can come and pick it, take it. I think you have seen those offers still. One indicating that whoever knows the people who fail to kill ABCD, how many shillings do they normally give? 20 million. Whoever knows the people who made an attempt to kill ABC. That is the spokesperson. So he has given an offer to the entire public. So please, if you want that 20, it's up to you. Either accept that offer or not. If you don't want it, it's okay. There are some people who wish it. So offer must be communicated to the offeree before he accepts it. The offeree cannot accept an offer unless he knows its existence, because he cannot accept it without intending to do so. If he cannot intend to accept an offer of which he is ignorant of, then the offer by, for instance, if A offers by advertising the reward of 5 shillings, everybody who returns this translator radio, and B finds the radio, brings it to A without having read or having heard about the offer, then he's still not entitled to that offer. That example very clear. This person has communicated their offer. Then another person who wants to take over that offer hasn't had it anywhere. Let's say he was out of news, but then he is the very actual person who picked the item. He brings it the actual owner. Is he entitled to that offer? People want to know why he had no idea of it. So it must be communicated. Then upon communication, the other party must also accept. So if you just speak without accepting whatever comes, then you take, to you there is no offer, but then there is an offer existing. you communicate. Now something you put in your mind and you fail to communicate, that's still amount to offer. Yes. 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 You will inquire, how did you come to know? Okay, how did you come to access this? To know that it's mine. And this person will elaborate, and this person will come to a conclusion that he was aware of the offer, or because how could he know? Could be having labels, yes. But then was he aware of the offer? And besides, offer, we have said that can be communicated in various ways. Can be published, can be made verbal, can be made in all sorts of communication. You can make it via your Instagram or your social media platform. Among others. Pardon? Yes. Once you return, you give it the owner, but you can't fail to give him his own. Now that amounts to what we shall say as conversion. You're going to see in the thought what amounts to conversion and debt. Yes, please. Okay. It's what we have just indicated. You're giving it in a good way. You have no idea that there's an offer. You have just dropped. So do you expect still the things regarding to the pardon your facts? Yes. For instance, A is indicating that whoever knows about his lost cow is awarding, let's say, 100,000. Yes. 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 It is still okay. He is giving it still, and in Christianity, okay. See, I wish how would you include Christianity and now some pastors in the Bible so that we concentrate. Authority. But it's okay. Still, we shall appreciate the principle. You okay? Okay. To take over that offer. Once you reject indicating that you're only waiting for the God's will, that is it all. So can I post you an appreciation? Giving that offer. I think that at the end you anyway, we are going to see the ways of accepting and yes. 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 Okay. Yes. Yes. I've given an example of Champion Group who was given an offer. Offer was communicated, the man never took over the offer. Can he be sued of not taking over the offer? Obviously, no. You have no implication. If I say that once you bring a phone to me, I'm giving you ABCD, and you fail to bring it, can I come and punish you because of not bringing? Obviously, no. It is now up to me to see other means. So offer is subjected to acceptance, first of all, and must be communicated. Yes, please. Yes, you have some. I've just given a clarity on that bit. You have given the ways under which an offer. We have first indicated that one must at least accept that offer. You must communicate. The company has communicated. Madman has picked it. Picking does it mean that he has accepted to take over the offer? Once he's aware that there was an offer, it's okay, he's entitled to his offer. Once he's not aware, he's not entitled. Yes. Is there a difference between an offer and a promise? It first inquired a difference between an offer and accept. Is it promise and acceptance? I mean agreement and now we want still a promise and an offer. Who can still answer? Same facts. Because you first need to know what amounts to a promise. Then we still appreciate what amounts to an offer. We gave a definition here for an offer, if I'm not mistaken. We first defined what amounts to an invitation treat, whereby we said an invitation treat itself is not an offer. For an offer, it is that reward person is giving, the offerer is giving to the offeree once it is accepted. You're giving it out, but then it is subjected to acceptance. That's why his example. However much, first of all, insanity, the person who is insane may not contract. So I won't see it under the person. But then the crucial part is even the offer was it accepted. This person just picked it, matched to the company, dropped it. Is he entitled to that amount? First, no. Why he was not aware of the offer. We are going to see where you are now accepting it after a long time. The man wants to do UNEP. It is his documents. He has those documents. He's indicating that whoever comes across these documents, he can take 1 million. And he makes it clear that whoever brings them before 1st of February, there's 1 million. Then you bring them on 2nd of February. Having known all the communications and everything, you bring it on 2nd of February. Are you still entitled to 1 million? So with offer, a person is willing to do something upon retaining something or having got what he needs. That's why we have indicated as you go to the shop, you pay for the items. It was just from a mere invitation, now you have accepted. But then with an offer, it goes ahead even from acceptance that even you first communicate. If I just give you the amount and you take it over, you have accepted. Acceptance comes in different perspectives. So let us first appreciate, but besides, all arguments are there because we haven't exhausted all these principles. So allow me to first, yes, please. Yes. Hmm? No, you can't reject. You can now come. You can't come again and say that you can't accept to be a thief. In other words, now you can sue for the breach of his offer he made. The remedy is that you can sue. No. Offer. One is asking that why would you even keep the phone until you wait for that offer? What if there's no offer? What if you're keeping it and there's no offer? It's not about waiting for the offer. Because now that one will change. What if you're keeping it, there's no offer and we have come to know that it is you with it. Then that one will take you to be now, you're converting it, conversion is this word. We are going to see it in thought. Don't know where I have my, okay, let me write here. So that one is conversion total. You're changing something which is not yours to be yours. So why do you keep it? Or to deliver it to the owner. Pardon? Okay. No, it is not a threat. We have just indicated that all offers so all offers must be communicated. Must be communicated. And upon being communicated, they must be also accepted. So you don't accept what is not communicated. First wait for it. But then if you have it, you can take it in good heart. It's okay. Then don't over demand or don't demand. Let it be an appreciation just. But then also the parties to it, they must be also be they must be known. I've just indicated that within the parties to an offer, we have the offerer, the offeree. Okay. I'll give you a minute a break, but I think let us first complete offers so that when we come, we can complete all the elements and see any other part. Having known that the offer must be communicated, offer can be given to an individual or set of, a group of people or entire community. By the case of Karel versus Kabalit Makubar. And in reference to that, let us see when does the offer end. A question that can be asked. At what stage can an offer come to an end? Or when does the offer be terminated? An offer can be terminated in the following ways. One, once you communicate time, because we have said all offers must be communicated. If you give a time frame and that time frame elapses, then that offer has come to an end. For instance, once you pick Chamuka keys right now and you deliver, can you still receive the vehicle? Those offers came to an end. Secondly, the manner of acceptance also matters. An offer elapses if it is not accepted. If I communicate and nobody accepts. So where there is no manner which is prescribed, acceptance is not in some usual way implied the nature of an offer. That is in accordance to Section 6, subsection C, the Contracts Act 2010. Death or insanity of an offerer or an offeree before acceptance. If this person who is giving an offer dies, or the one who has picked that item also dies before delivering it, that has taken away the entire offer. That okay, members? Yes, when the contract that, when there is death or insanity. What do we mean by insanity? Yes? It deals with the aspect of mental or mind. So if you're not in your conscience, then you cannot indicate that you have accepted, or you cannot make an offer, neither can you accept the offer. So a mad person can still to accept the offer. His mental element can affect him. Then counter offer can also terminate an offer. It normally comes, actually, it is one of the elements that is asked. What do we mean by a counter offer? Objective, when they bring counter offer is, then they bring those elements. Counter offer is this second offer that turns down the first one. We get it. There has been an existing offer, but then another person is introducing another one to replace that one, even if it is still in existence. Once the new one starts, then the first one or the initial one elapses. We get the point, members? That's why they are indicating that when a counter offer is made to a contract, the offer terminates and cannot be retrieved by the person to whom it was originally made, even if that person is prepared to accept the original offer unconditionally, similar to the rejection C in the case of Hyde versus Range. In other words, if I say that whoever brings a smartphone, I'm willing to give him a laptop within a week time. And before even the week ends, I change my mind and still communicate. Now, whoever has a phone, I'm giving him a laptop and also 1 million. Now, if you're coming with a phone, what do you expect? Do you expect a laptop only or even a laptop with 1 million? Because the second offer now takes over the first one. Same applies if I say that whoever brings the phone, I'm now reducing the laptop, I'm only giving him a calculator. So if you bring a phone, I give you a calculator. So the second offer overturns, replaces the first one. That's the implication. No matter whether it is good or bad, it is replacing. Once you accept it, it's up to you. So that's what we mean by the counter offer, that the first offer is taking over the second one. The second offer is taking over the first one. Then revocation. What do we mean by revoking? That a person changes and stopped it over. Revocation. It's what? Number 5, revocation. Revocation terminates an offer with revocation, also known as termination, can aid to come to an end of the offer. How does it make it? If I say that whoever picks my smartphone, I'm offering 1 minute. Before a person gets it or before you come to me, since you had an advert, I still communicate that please, the other 1 million I was talking about, I've used it in medical bills. So there is no, whoever picks my phone, there's no amount. So I've terminated the offer I had. So whether you bring it, I can't give you any other amount. I terminated. That is revocation. So is there any question in terms of offer? Yes, what is it? I want to address it, then give you 10-minute break. We come and resume. Death and insanity. Death stroke insanity. It's not one word. Okay? Yes, before acceptance. So if you tell me that no, the person who had fixed it is my dad, that's why I'm doing it. Then the one who had accepted. Next of kin. If it's authorized, the first with the legal representative or the third party. We are going to see within where another person can substitute and get the same benefits. Same, we are going to see what amount the law of privity, that if you're not party to a contract, then you cannot enforce it. For instance, if the offer is only given to Champion Kudu, can his brother come and take over that offer? No. Same in terms of a contract. But then if there is that option that if he doesn't want to take, then his next of kin or any other person responsible can come and take over. And there's a person who is employment. Can he come and take over? So we are going to see the law of privity. Allow me to give you 8-minute break. Just come and we deal with all the elements and see what next. Once we fail to complete contracts today, we shall complete them next time and deal with another topic. Because we have limited time, but then we need to appreciate. That's why I'm not rushing, but then we need to appreciate these principles. There are 7-minute breaks. That's now exactly 12 minutes past 8. We shall resume. So, online students, we are back. Let us kind of resume and see what we can still capture under road contract. So this offer, I think we have dealt it as one of the sub-elements. Then we have acceptance. What we need to appreciate under acceptance, that acceptance is only possible if the offer is still in force. You only accept where there is an offer existing. Where offer is not existing, you cannot accept. I think that is very clear. Besides, if it is in existence, if the offer is in existence, acceptance comes when it is absolute. So you accept when you have absolutely done it. Therefore, if you're only accepting with a particular condition, would not be allowed. Find that you have that condition that, yes, I'm willing to give you that closed phone where the offer is at 1 million. However, I have other debts in the bank. Can't you add 50,000? So if you put that condition in terms of acceptance, it is not allowed. We appreciate that in terms of acceptance. You accept unconditionally. You accept absolutely. You completely say, I've accepted to take over the offer. But once you put some conditions or restraints, then that acceptance cannot be admitted. Also, whenever you're making acceptance, you must communicate. Communication of that acceptance. How? On a principle and unexpressed acceptance or unmanifested asset to the offer does not result to a contract. So we have those supporting cases. So you also communicate that indeed you have accepted that offer. According to the other offer, I'm willing. I got this item, that's why I brought it. Secondly, that if the offer is one of which is to be accepted by acting upon. No? Hoping that is hoping it was an opta dicta, by the way statement. Opta dicta. So we are very clear that once there is an offer, you communicate your acceptance. If Champion Kudo wouldn't take over the offer, he could still communicate that I'm not willing to accept your offer. So a mere putting some conditions that I'm willing to take over that offer you have given me, so I'm accepting on a condition that you only bring Mercedes-Benz Pygmy every day. Then that is not acceptance of that offer. Besides, if the offer, acceptance also can come in where if the offer is one of which is to be accepted by being acted upon. There are some offers whereby person says, whoever is willing to take over this offer should do this. So he has given an offer, but not the condition. If you're willing to take over that offer, you still need to feel that element part of the offer. We get the point?
Isaiah. Yeah.
Yes, Madam Patricia, can you mute? Thanks. So if there's no communication, the intentions, acceptance is necessary unless communication is created for the offer itself. It is an offer of reward. If an offer of reward is made for finding a lost dog, the offer is accepted by finding the dog and is not necessarily before beginning to search for the dog to give a notice of acceptance. You get that point clear? If the offer is like whoever picks a dog, Miles' dog, is supposed to obtain this. You can't say that you have accepted the offer, then you start looking for the dog. it is upon you getting a dog, then you say it's now the time to accept the offer, not beginning by accepting before obtaining that item. Okay, and lastly, the best principle is that a statement addressed to one party to another is effective in law only if it is communicated. So even if you have accepted, you also communicate. Law, you must effectively communicate with each other. A distinction is drawn between acceptance and serious contracts in one of the contracts by a post. If you to accept through a post, or it is one of the means, then you still need to use the post method. Acceptance, now they are giving you the examples. That's why we have the post office rule. If they say that if any employee or any person willing to take over this employment contract must also communicate through a post office address. You can't communicate your acceptance through email. Why? It has the condition that you also use the post office. Okay. So they are indicating what amounts to acceptance and the post office rule. The general is that acceptance must be communicated to the offerer to be effective. Post office rule is an exception. The post office rule is an exception that post office is where the post is reasonably to be expected by the means of communication. Then the acceptance takes upon effect by posting it. So you only accept if it is post office, you still accept by going ahead to post it again what is required. However, it has also exceptions. So they are indicating when the post office applies, acceptance is complete as soon as the date of acceptance is posted, prepared, and properly addressed to the person who made an offer. They rarely set on that for the post office rule. They rarely set. And maybe for an agreement, being that is one of the elements, an agreement, here they're indicating that when the offer and acceptance correspond, if A offers, then you have accepted. The next step is what? Making an agreement, as simple as that. So where there is an offer and another person has responded by accepting, in every respect, the parties have reached an agreement. It is said that they have gone to what we call in Latin as consentium ad idem, or consent at the same thing. The valid contract has come to existence, provided that the other requirements are all present. So that's why I say that all elements must be present. When if you communicate, the other person accepts, but then capacity is not admitting, then it cannot be a valid. Then cannot be a valid contract. All elements must be present. Then let us see another element of consideration. What amounts to consideration? That was where most of the questions arose. Consideration is something, is some of the benefit or received by the party who gives the promise or platforms, or performs that act. Or some detriment suffered by a party who receives the promise may be defined as that which is actually given or accepted in return of the promise. That is consideration, something you receive in return of the promise. It was defined in the case of Julie versus Misa. Normally comes as an objective. I think within the questions, within the set of the trial paper I've sent in your group, there must be that case, and it was an objective asked. If not, then it is within the part B of the question. So where they can ask you, in that case of Mr. versus Julie. So they want you to appreciate what amounts to consideration. and the rules governing constellation. But then, in a simple and precise way, we shall all indicate that constellation comes in as accepting what has been promised. One has promised this, then this person has accepted, and now whatever is giving in return, in exchange of that item, is seen as a consideration. So it was defined in that case of Julie versus Mr. 1875 as a sum right, interest, profit, or benefit accruing to one party, or some forbiddance, retributive loss, or responsibility given, suffered, or undertaken by another. But this is not a definite, but this definition, that should be added the benefit of accruing or detrimental sustained by in a way of return to the promise which is received. Examples of consideration include A receives 500 shillings or 5 shillings in return of this promise to deliver the goods to B. Here, the money A receives is the consideration for the promise he makes to deliver the same goods. So that interest or something you're receiving in return is what we are now considering to be a consideration. That's why they are giving a second example that C promises to deliver goods to D, and D promises to pay for the goods when they are delivered. Here, the benefit C receives is D's promise to pay, and in return for his promise to deliver the goods. In other words, you're losing something, retaining another item. That is the consideration we're meaning. So that payment you're obtaining. And the last example is that X lends his book to Y, and Y promises to return it. The advantage is entirely on Y's side, but not X. The detriment is parting with the book, and in consideration to support Y's promise is to return it. So even if it is not money necessarily, but what you have promised to do is what we shall still see with that consideration. But besides, let us appreciate the two types of consideration. We have what we call executed consideration and executory consideration. So how do the two differentiate? When the act constituting consideration is completely performed, then the consideration is said to be executed. An example above is the one of paying B, a payment by B to A for the executed consideration. When consideration takes the form of a promise to be performed in the future, it is known as it is the executor in example of the consideration. Therefore, it is executory. We get the examples. So an executed consideration, therefore, an act done by one party in an exchange, the promise made or act by another. The executory consideration is the promise made by one party in an exchange, the promise made to another party. How can I bring this to the live examples? Executed and executory consideration. If you leave a housemaid at home and his work is prepared for you supper, on arriving, you find that the house girl went ahead to graze cattle, and it's indicating to you that the mere fact that the husband was not present, he had gone to a party time, he needs 20,000 to graze. Separate from the salary, can you fulfill that payment? He needs 20,000 as this consideration for grazing in the absence of husband. Separate from the salary. Can you execute that consideration? Can you pay him or her? No, that man is also on the monthly salary. This one is on monthly salary. Only that what has occurred is the interchange of the work. This one doing the work of the other one without even communicating to you that he has done it. But upon you returning, is now indicating you clearly that he has performed the role and he needs payment. So there, that is known as executed consideration. In other words, this person can pay you or not because you have no legal obligations. Even if he pays you, it is a mere appreciation, not consideration. Why? You never communicated to him that you're going to perform that role. It is now upon the role being performed that you're requesting for the consideration. We get the point, members? It's like when you indicate that in December you want to harvest. As December approaches, you find that people helped you in your absentia. And now they are demanding payment. You have the right of paying them or not. Why? They never communicated to you that they are harvesting. So that you can prepare in advance to tell them the price you're setting for the harvest. That is executed. In other words, you have done something without notifying the other party, and now you have notified him upon completion of everything, and you're demanding for that consideration. So that party has a right to give you anything or not. So in law, executed consideration is not consideration. But executed, where you agree and you set the amount you will pay, and the other person accepts, is that consideration which is lawful. We get the difference of the two? Yes or no? Okay, so let us see the general rules that govern consideration. Yes, please. You pay. So now this time round you must pay, since you are the other party. So now you want to bring it in implied contracts. That since you are paid last Christmas, the other people who did the work without notifying you, you also pay us. That consideration is executed. He has the right of paying you or not. But then, yeah, he doesn't have any obligation. If he pays you, it's on his wish. Let us see the general rules governing consideration. Normally comes. Last time they brought the rules are confirmed. They brought rules governing offer, so you never know. Those could be in consideration. First one, consideration required for all simple contracts. One, consideration is necessary for validity of every contract, not in a deed. Even contract in writing require it. The promise without consideration is this example here. Once you promise something, but then you're not giving any consideration, it is that matches with the other examples we were giving, and with the case of merit versus merit. There was no consideration. I mean, the one of Barfa versus Barfa, but in merit, there was consideration. So a promise without consideration, once you promise something, but you're not indicating how much is in return in case they bring, and that's the mere gift. So some of you, whatever you do in Valentine era, those are only gifts you're giving. Find one indicating that this was just support me. Read at home. Everything, then you indicate. Those are mere promises. What if that night there is no effort of a lady? Will you still sue, or will you take the fridges you gave them as a gift? So there must be a consideration. The other person must communicate that however much you are about to make fridge, be assured there's a law. So a promise without consideration is a gift. One made for a consideration is a bargaining. So in consideration, you bargain. That's why I gave you an example of the executed one. He has performed the role without bargaining with you. He never bargained, and he needs money. So you have the right of paying or not paying because you never bargained. So once you pay, it's just a mere appreciation. But whenever you bargain, then you must fulfill that consideration. Then consideration must be of some value, and consideration must be of some value, but not need to be adequate. What does it mean? That it must hold some value. Person may appreciate. It may not satisfy what that person needs, but at least it has some sense of appreciation. We get that point? You on the second one. Consideration must be of some value, but not adequate. That means if you indicate that this once you do this work, I'm paying you this amount. If you can sort up or make out, I'm only giving you 100,000. And this man accepts that. No, you add 20K, then you add. Then before even completion of slaughtering, the cow adds that very man. And now it's like, no, please. The other one was a fool. At least I know that was the year. So add 50,000 on what we agreed. Can you add? This one being the consideration you accept, the consideration you gave out was of some value that the person couldn't hesitate. So whether it went in other expenses, what you agreed, what you have gained, enough. We get that point? Yes. Then consideration must be legal. Something which is legal is something which is accepted in courts of law, or something which is not prohibited by any law. So an illegal consideration makes the whole contract valid. Those are the implications of a consideration, or the rules governing consideration. Then lastly, consideration must not be by past. I think it was the one which I explained the most. That the past consideration is the one which is the whole executed and finished before the promise is made. It must be distinguished from an executed consideration, which is given at the time when the promise is made. Examples: X agrees to give and actually gives Y 50 pounds in the return of Y's promises to go to Paris and transact some business for X. Here, X gives an executed consideration since the promise to go to Paris is given at the time of the 50 pounds Ghanaian spoken. So, but basically, just consider the rules governing consideration. That consideration must not be passed. It must be of a value. Then it must be of sufficient, not adequate. It is one which has something but not satisfying you the maximum. Then it must be legal. That's why I could give you an example that if A is supposed to kill B, and the promise is, what if I say that, okay, once you sell me the fridge, I'm entirely giving you Lake Victoria. Or the words you normally use in your relationships. That the mere sitting beside me in class, I'm giving you Albert and also the mineral salts in the entire country. Then the person sits. That consideration. There's a student who once said that once you teach today, I'll be staring at you entire day. So the consideration is when you go out, please give me what they are going to say. I couldn't fulfill how. You're supposed to learn everything. So how do you give me sport? But I can aid in giving general idea. Constellation must move from the promisor, the one giving that promise. Because we have two parties in a promise, in a constellation. We have the promisee and the promisor. See with SEE at the end. Another one with SOR. So constellation must come from the one who is going to. So this means that the person to whom the promise is made must furnish the constellation. We have that case of Daniel Taya versus Selfridge. Let's just understand those 5 case rules governing constellation. It will be good to do a number in contracts. Let us deal with capacity. And if you have a question, a question on the constellation part. Is there a question? Capacity to contract. One of the elements, remember in the definition, we said it must have a lawful constellation and the capacity of the parties. So let us see who are the people capable of contracting. One, as a general rule, in Uganda, who is on a majority age, person of power. So every person of 18 years has the right to contract. That is very true. But then we are going to see scenarios whereby a person below 18 years can contract. For instance, it is true. As a general rule, only to contract you must be 18. But minors can contract. And what exceptions? These are the ones who are going to speak. A minor can contract, has capacity to make a contract if that contract is made for necessity. We clear, members? A person below 18 years can sign a contract on a necessity part. So what amounts to a necessity? Should be the question in your mind when you're dealing problem question. Something which is crucial at the time of entering into a contract. So if a minor is sick and he needs medical care, can't that medicine be a necessity? Can't you go into a hospital and contract? Then you come, they give you a bill of 1 million. If it is a school requirement, for instance, if there is accountancy course in primary and the kid of 10 years contracts with the canteen manager to obtain a set, 12 set and a calculator, 12 women calculating, can it be necessary at that particular time? What if he buys a set on Christmas Day? Is it still a necessity? So necessity varies at the time. That's the first element you need to appreciate. So the necessities are not restricted to things which are required to maintain the bare system, such as bread and clothing, but to include articles which are reasonably necessary. The minor having agreed to his station life. Therefore, sale of goods and supply. This act was amended. The current act is sale of goods and supply of service 2018. So sale of goods clearly defines what necessity means, or necessary. Necessary means goods suitable to the condition in life of a minor, of the other person concerned with this action requirement at the time of sale and delivery, or the time of making a contract, when we can calculate. What if now you signed the contract when you were 17, because you're still a minor? Then the person who is enforcing it is enforcing it when you're 21. Is it still the contract to be enforced? So we shall always calculate the time when you enter through that contract. So where the necessity, when the necessities are the goods, the minor is only liable when the goods are one. So for you to satisfy a person that this was a necessity, these are the conditions to meet. First one is that it should be suitable in his condition of life. The second one being necessary requirements at the time of sale. That's why I'm giving you an example that you cannot buy a suit on a day of reporting to school and you say that it was a necessity if you're a minor. At that moment, suits are not allowed. But then you can buy a suit at a party time. And now we say that it was a necessity at that moment, isn't it? So necessities differ at the stage and the suitable time in the lifetime of a child. And the last one is that necessary to his requirements at the time of delivery. So it depends even on the delivery time. If this is the minor who went to the canteen and requested for a set, as they were going for a mathematics paper, then they deliver it after the paper. Is it suitable to that minor? So at the time of sale, it was necessary. But delivery time, it was not necessary. So that contract still cannot be enforced. So you cannot say that, yes, however much I had no sales, I ordered, but then I couldn't know that you had a paper. So even if you had ordered for those days, and now the person is out of the paper, it cannot help him and you cannot enforce that contract against the minor. Any question in terms of a necessity for minors? Second element where a minor can contract beside necessity is in during education, during the education and employment contract. But then the basic authority under necessity, we have the case of Nash versus Kinnaman. Is here. In Nash versus Kinnaman, here. Nash versus Kinnaman, the minor who was an undergraduate at Cambridge for 11 University, Wisconsin, from Nash. He was at the time adequately provided with clothing, but when they went to court, court held that the went to court were not necessary, and I was not. It was not liable to pay for them. One was enough, but 11 were not necessary. Get the difference where it is. Yes, it was a graduation party. The other first suit was necessary, since this was a minor. But 11 suits were not necessary. So if it was any obligation, the parent or the person who was responsible for the minor would only pay for one suit. Okay, so the second element, apart from a necessity, where a minor can make a contract, is on education and employment contract. So these are actually, education is one point and employment is another point. So we have only 3 elements where a minor can contract. Necessity, education, if it's contracting for anything in regard to his education, is allowed. And the last one is employment. But the only element here in employment contract is that a minor can contract for employment or can enter into an employment contract only if that nature of employment is not hazardous to his life. That's okay, members? And cannot and may not affect his study activities. For instance, in 2018, it's when Fresh Kid almost rose to fame. He was contracting with various shows. They were signing him to come and perform, and he was at school. So if singing or if performing was part of him not affecting his entire curriculum in terms of academics, that work is okay. But now you can imagine a person who's like Fresh Kid, 8 years, being contracted to a Stony Quarry. That activity was there for employment? Yes or no? Stony Quarry, 18 years. We are paying you 100 per day. That is hazardous to his lifestyle. So the nature of employment depends to the minor. Those are the only 3 conditions under which a minor can contract. Let us see where capacity contract can also go in terms of companies, corporations, or companies. So at what stage can a company contract? Remember, we are on the issue that a contract is an agreement. I mean, a contract is an agreement entered by parties with free consent, with capacity. So we are on the element of capacity. So companies can contract. I think we are all aware of it. That as a company is known as an artificial person, you are the natural person. A company can also contract. Haven't you seen property in companies? For example, in all your desks, there must be a label of CAM as an institute, abbreviation of Capital College, Accountants, and whatever. So can I take that seat? Obviously, no. It belongs to a company or an institute. Same applies. So companies can contract. That a corporation or a company is an artificial person created under the law. It is very distinct from individuals or persons who are members of that corporation and has a legal entity. The definition of what amounts to a company is in the case of Salmon versus Salmon. We are going to see company law, I think, after the next lecture. The next one will be about company. So that's already the definition given. So, but the issue is, can a company contract? Yes, because once the company is registered, it has capacity contract. It has capacity to sue and can be sued. Haven't you seen companies being sued? So we are dealing with capacity. So even companies have capacity to make their own contracts. Okay, however, maybe the crucial part on it is that companies contract through the directors or the personnel who are responsible for running that company or any company. There is no director who can contract where is balanced or limited by legal means. So if, for instance, if your company indicates that it doesn't exceed 1 billion, can that company contract to do an activity for 2 billion? That is exceeding the limit. It's not allowed. So they are limited to a legal bounds. Second to that, if the activities done are illegal, they are also not supposed to contract for them. A company cannot contract on an illegality. So those are the conditions that one can know. What do we mean by this item? Ultra-virus doctrine, acting beyond, outright acting beyond the powers you have. So if a company has a some limit, it can't act beyond that limit. Once you appreciate that, you're good to say that with companies, they can make a contract, but they cannot go into contracts which are beyond what they are supposed to do. Third category of capacity of those who can make a contract, we have this one. Drunkards can contract. An insane person can contract. A lunatic can contract. How? That's why we have that mentally distorted and drugged person can also enter into contract. Contracts made by mental distorted persons are referred to as mental, are defined under the Mental Health Act of 1983. Therefore, the mental patients are valid unless those persons are present under the jurisdiction of court, which is below, or if the other party knew about that he was contracting with a person who, by reason of unsoundness in his mind, could not understand the nature of contract. As simple as that. What we need to appreciate under the drunkards or the mentally disturbed people is that they can enter into a contract on only one condition. That at the time of entering into a contract, they were aware about the implications of that particular contract. As simple as that. Now, what determines that the person is the drunkard or not? Once the person takes 5 bottles, is he a drunkard? So at what stage does that person become a drunkard? Yes, for those who take beer, you can advise us at what stage do you think that you are now drunk? Upon taking 10 minutes, you're drunk. So we now make it as an issue that every drunkard upon 10 minutes is drunk. This is very simple. It depends on the capacity of the person who is taking. We have some comrades who can take 5 crates, and they are still okay. We have those who take Seminole, tipping it is already down, pretending that they have put spare tires beside him, yet he's still in the seat. So drunkenness depends on a person. I mean, the level of drunkenness depends on each and every person's capacity of consumption of that alcohol. Also on the percentage of alcohol and the nature. So that is with drunkenness. Allow me to conclude with the reality of the contract. What we, of course, it was also an element of the contract and it was towards the end, make it legally bound. So, how do you know that upon fulfilling the other element, how can you come to know that this contract is enforceable, is legally bound? That one takes us to be the reality of the contract. Reality of a contract is also known as an element that can vitiate an entire contract. So for you to know that this contract can be enforced or not, it depends. And therefore, that's why we have that. The reality of contract are rated from 4 categories or 3. Unenforceable, voidable, void, and illegal contracts. What contracts are unenforceable? What contracts are voidable? What contracts are void? And also illegal. Have them here. An enforceable contract is the one which is valid but cannot be enforced by an action because some technical defects, such as in the case of a contract of guarantee, the absence of the note or memorandum in writing as required by that Act, Statute of Frauds, as 1677. What do I mean by an enforceable contract? That it is that contract, it is valid only with meeting some conditions in it. If you're signing a mortgage agreement, or if you want a loan in a bank, and they're indicating that they need a surety, a person is going to sign a guarantee, a guarantor. If you don't have, can you indicate that you have your contract is valid? It is not until you bring that guarantor. Some of you have committed offenses in court in the police. You have often been taken police cells, and they say, for you to give you a bond, we want. How are those people called? When you're getting a bond at a police station, the one who comes in, then signs. They say they want a surety. So without a surety, you cannot be released. Same applies to court. If a person has been confined and is at court cells and you need to get him out, then we still need sureties. So it is a condition. In other words, a contract can only be enforced when that surety is there, if it is the condition. Then we have what we call a voidable contract. A voidable contract is the one which all the parties can put by any at the option, at its option. A voidable contract is the one which the parties can put an end to as at its option. This option can be exercised without the reference to the other party. Let me simplify this. A voidable contract is a contract which one party can come to an end, only the innocent party. Am I clear on that? Innocent party, how? If you're supposed to sell a phone to me, and at a consideration of 1 million, then I pay almost up to 80%. I get sick, the extent that I tell you that, please, I have almost abandoned. I may not fulfill what I have promised. It's up to you to come to an end. You're the innocent party. I've failed to meet what I'm supposed to do. So it is now you say that I've terminated the contract or not me. It is not me to say that, no, I've failed to pay, so I don't want the contract. No. The one who's supposed to do an act and has failed. Then the other opposite part, the one who is waiting. In other words, if you do your part and the other party has failed to do his part, the one who has failed to do the part cannot say that we end the contract. It is now you who has done your part to say that we can come to an end, or I've given you a grace period, or you can extend it in whatever way. You get that point? And lastly, the void contract is that contract which totally lacks any element in a valid contract. So if there's no capacity, it's valid. I mean, it's void. If there is no consent of the parties, void. So for it lacks all the elements in either all or any. Once it lacks, it is a void contract. Are we clear with that? So with these elements, next time I'm coming only conclude here. These are known as vitiating factors, factors that can change the terms of the contract. We have a mistake, we have undue influence, we have duress, and what else? Fraud. So these are, we shall, next time, shall begin with mistake, followed by misrepresentation, duress, undue influence, and what? Yeah, basically that, then we conclude contracts. However, I've posted problem entire paper actually, trial test in your group. If there's any question for now, I can answer it in it. Or if there's any question in this regard, because I don't want to show most of your time for today. But then the next time we shall come, we are only concluding with contracts and we shall deal with agents also. So the first hour, we are concluding with contracts. Then the next hour, we shall begin with agents if there's no any other hindrance. Any question? Yes, please. What is the difference between a void and illegal? They are similar. Void contract lacks the element of a valid contract. Illegal contract is that element which lacks the valid elements of the contract. So they are similar. Just use interchangeably. Any other? Yes, the question I've sent in the group. Yes. We do it when? Right now. Next time. We can do it next time anyway. Let us make it clear in this way. Read through it. I'm very sure that there is a number concerning this contract. Very sure 100%. Both in objective and also in part B of that now of that paper. Is it there? Which number is there for contracts? It's okay. So let us, we shall come complete contract. Then, if possible, I can still surrender that agents that I will talk about. We deal with the number there, so that we can all have an approach. Because it would be injustice if we start answering before having the notes. Any other question? Other than that, then I wish you the best week until we meet the next day. On incidents, you're free to log out. Okay, welcome. Also, okay, that's great. I was there. Yeah. The business, right? Yeah. The numbers increase. Because if the user is change, also like 15.